Welcome to this celebration of International Women's Day. I'm Stephanie Harrison QC. I welcome you to Garden Court Chambers, along with my colleagues Emma Fitzsimons, who's a barrister in Chambers, as well with Uba Deary, and we're very pleased to welcome Priscilla Dodia, who's the Policy and Advocacy Coordinator of Women for Refugee Women, to share in our discussion today on the big topic of the impact of the Nationality and Borders Bill currently going through Parliament, which we believe will have very damaging, disproportionate adverse impacts on the rights of women and girls seeking refuge and protection in the United Kingdom. So we've chosen a topic, obviously, because it's a pressing topic. It's a major issue that we face in terms of women and girls seeking asylum in the UK, but also obviously at a point in time when we have looming refugee crises around the world. Of course, today we're focusing on the situation in Ukraine. 600 this morning, women, and mainly women and children, are in Calais looking to be reunited with relatives in the UK, and at the moment not looking like there's a safe route for them out of harm's way and into safety. But of course we know that the Ukrainian women, children and men, of course, join vast legions of people who have been escaping violence, war, persecution for many years, obviously on the back of a major crisis in Afghanistan following the return of the Taliban and what can only be seen as the likely institution of a regime that will be akin to apartheid for women and girls. They have not had the same sort of international response, but they too will be seeking to come to the United Kingdom for safety and protection of the Refugee Convention. And it's that we're going to focus on today. We're going to look at the different ways in which this bill, which I describe as an act of revenge, many decisions that have been taken over the last 20 or 30 years to the benefit to refugees, whether it's in terms of interpretation of the Refugee Convention or the safeguards in terms of the process, will, if this bill is passed unamended, be overturned. It's also an act of vengeance because it is motivated in the context of an acute, long-standing campaign of vilification and demonization of refugees and asylum seekers. And it's something that we are not only going to talk about, we are also actively engaged in seeking to challenge this legislation. And members of Garden Court, Uba, myself, Emma and others, along with Women for Refugee Women, have focused their attention on campaigning to get members of Parliament to put in amendments to this legislation, and I'm sure you'll hear about how that strategy is going and where we might end up with what this legislation will look like. Because we're feminists, because this is International Women's Day, we're about deeds, not just words. So although we're going to be talking about what's wrong with this bill and how dangerous it is, I hope it's also a call to arms for people to get involved in the campaign to resist it and to challenge it both now and, of course, if it does come into law. Today there was a moving sight outside of Parliament. I don't know if many managed to see it, but there were many women, domestic workers, outside Parliament supporting and celebrating the decision of the House of Lords to successfully put an amendment to this legislation providing for the right to work for those who are seeking asylum. That's long been a major source of harm to asylum seekers, that they have been left unable to work, unable to support themselves, unable to have the dignity of being able to earn their own living and be independent. And of course, it's unlikely that will remain successful in the Commons, but it's an important moral victory that recognise just how pernicious and outrageous truly it is to deny people the ability to sustain their own lives by working. And so I hope that that's going to be a model for other successful amendments, if only in the House of Lords, to this legislation. So having given you that general introduction, just in terms of how we're going to proceed today, in the usual way, there's a Q&A function. So as we go along, you can put questions into that. And if it's appropriate, we'll answer them as we go along, but probably more likely we'll have an opportunity at the end when everybody's spoken. We're going to hear first from Emma Fitzsimons, who, as I've said, is a barrister in Chambers. She specialises in immigration and public law, in particular asylum, unlawful detention, trafficking, age assessments and community care. If you know Emma, you'll know that she's a committed and conscientious advocate. Her particular strength is in representing vulnerable clients. She often appears for unaccompanied minors, victims of trafficking and vulnerable adults in all levels of the court system, including the administrative court. And she has a lot of experience in successfully acting in urgent removal cases. She's also one of the contributors to McDonald's Immigration Law and Practice, which we were very proud to get out this year as the 10th anniversary, the first edition without Ian MacDonald as its editor, and we were lucky to have contributors like Emma and both Uber who contributed to the 10th edition this year. Emma's going to give us an overview of the legislation and its impact on female asylum seekers, looking in particular at the pernicious two-tier system that's going to be created if it comes into law and its legal effects. Emma.
Thanks very much, Steph. I'm just going to share some slides now, so if you just bear with me for a second. So, hopefully everyone can see the slides now. Yes, okay. So as Steph said, today obviously we're focusing on the experiences of refugee women and girls. And in this part of the presentation, I'm going to speak first of all generally about the experiences of women and girls claiming asylum, and then outline a bit of the context to the bill before looking at in detail Clause 11 and the differential treatment, which is also referred to as the two-tier system. So to begin with, and to pick up a theme that Stephanie highlighted in the introduction, one of the main justifications for the bill that's been put forward by the Home Office is that there are an abundance of unmeritorious asylum claims coming to the UK, and that's frustrating the asylum system, and it's resulting in the court system and the Secretary of State being overwhelmed by late claims and late attempts to frustrate removal. But in actual fact, it's worth myth busting from the outset using the Home Office's own evidence. And you can see from this slide that the top 5 nationalities for claiming asylum in the UK last year were from Iran, Eritrea, Albania, Iraq, and Syria. And those are obviously 5 states where there's either currently conflict or political strife, or indeed, as is recognised by the Home Office, genuine reasons why a person might be fearing persecution. For example, in the context of Iran, the Home Office has a number of policy documents which recognise that Iranian women may be at risk of forced marriage or honour-based violence. Similarly, we know that the Home Office also recognises that Albania is a source country for trafficking, particularly of women and girls. And so the rhetoric from the Secretary of State justifying this bill doesn't match up with any of the evidence base that's being put forward. And particularly when it comes to women and girls who are already a vulnerable group, it's important to bear in mind that their protection needs may arise from the typical, if we put it in that way, theatres of conflict or political and religious grounds, but also as a result of being a woman. So as we've already discussed, there's issues of early forced marriage, maybe honour-based violence, there's trafficking and modern slavery, gender-based violence, including domestic abuse, FGM, denial of education, and persecutory discrimination. And it's been a hard battle to have those forms of harm recognised as being within the context of persecution for the purposes of the Refugee Convention. And when I was preparing for this presentation yesterday, I went back to something that Baroness Hill had said in the landmark case of Kay and Fauna. And I thought it was actually really interesting that in a case about whether the harms that women face could amount to a convention reason for the purposes of the Refugee Convention, looking at particular social group. There are obviously speeches from all members of the House of Lords, but when it comes to Baroness Hill, within the couple of opening paragraphs, she says that the answer to her is blindingly obvious. Of course, women are covered by the convention. If women are not covered by the convention, that would be contrary to international law. And in particular, as she set out here, the guarantees in both the ICCPR and also CEDAW. So they are hard-fought gains in order to make the kinds of persecution that women have faced visible and protected. And this is often, I think, something that's being forgotten in the narrative that's being put forward by the Secretary of State in introducing this bill. So picking up from that, why are the lived experiences of women and girls so important when it comes to asylum decision-making? Well, the first point is that the bodies of women and girls remain battlefields, as they do in most aspects of law, unfortunately. And the kinds of harm that women go through are often of a sort that are highly traumatic to disclose, to discuss, and to have to repeat over and over to numerous people. For example, an average female asylum seeker might have to disclose her claim to a Home Office port officer, an interviewing officer, a welfare screening officer, then her own solicitor. There may be a change of personnel within the firm. Then there's a barrister often involved. Then you have the tribunal hearing if the case is rejected in first instance. You have a judge and a presenting officer as well asking questions. And it's important to remember, I think, the humanity of the individual in the context of that process, because what we're asking women refugees to do is to continually disclose and discuss the worst possible things that have happened to them. And in that context, it's unsurprising that there are going to be barriers to identification, disclosure, and gathering evidence. And of course, sexual and gender-based violence is not always visible. It's also not always easily recognisable. And it often depends on the attitudes of the state and the society around the individual, and also the extent to which they've maybe internalised the misogyny around them as well. Those are all barriers to self-identification, which means that it's not always possible for a woman to be able to disclose her claim at Heathrow Airport as soon as she arrives. And that's something that's really important to recognise from the outset, particularly when we go to look at the clauses of this bill. And then finally, there's also the problems of intersectionality and the impact of conflict on women and girls not always being well understood. And that's unfortunately something that we continue to see even in the asylum process, despite much better practice and learning on the subject. So then to look at the bill itself in a bit of detail, the Nationality and Borders Bill follows the new plan for immigration, which was a consultation paper put out by the Home Office around this time last year. It was a very short consultation period, and there was an overwhelming response from the sector that the contents of the consultation were deeply troubling and without a real evidence base. Unfortunately, the consultation didn't result in much or any meaningful response from the government. And the bill was published just before the summer without much scrutiny of the consultation responses. When the bill was first published in the summer, there was no equality impact assessment. One followed in about October, but even then the assessment itself was fairly inadequate and didn't really deal with the various recognised barriers that women and girls face. It also didn't deal with the main critiques put forward by very reputable voices within the immigration and asylum sector. And also, given the timing of it, it was unclear that many parliamentarians had had the opportunity to properly scrutinise the contents of the assessment. The bill's now currently at report stage in the House of Lords, and I believe today they were debating part 5, which relates to modern slavery. And you see on this slide, we've given the link to the live link on the Parliament website, so you can follow along and see the bill and the amendments that are being proposed. Today's focus, given our partnership with Women for Refugee Women, is to look at 3 aspects of the bill that will affect refugee women. And these are found in part 2 of the bill, and they will involve the overhaul of the asylum system, as Stephanie indicated. I'm going to deal with clause 11, and my colleague Ub is going to deal with clauses 31 and 32. And also Priscilla's going to draw on all of the work and the learning that Women for Refugee Women have done to highlight their lobbying efforts in this context. So just to begin with, it's worth noting the unprecedented intervention by UNHCR on this bill. UNHCR has published 2 very detailed policy papers in which they've set out very detailed observations on the bill. The most recent was published in January of this year. They are very critical of the bill, and they've rightly said in Hansard to the House of Commons that the bill will undermine and not promote the government's stated goal of improving protection for those at risk of persecution. And it seems to be aimed at deterring refugees, but there's no evidence that that would be the result. So much of the rhetoric around the bill has been about trying to break up smuggling gangs that profit from migration crises. But in actual fact, there is nothing in the bill that will affect those criminal groups, and all the bill will do is adversely impact refugees who are claiming asylum. And so it's in that context that we wanted to specifically highlight some of the issues with respect to women and girls. So moving on then to look at clause 11 in some detail, I should just say that we're referring to the clauses as they are in the government's version of the bill introduced to the Commons. And there's been some gains in the House of Lords this week, particularly about defeats. But you'll see here that what the government proposed to introduce in clause 11 is a differential treatment regime, which has been referred to as the two-tier system. I've put the text of clause 11 across 3 slides because it's actually quite important to see what the effects of that clause will be. So you'll see there at paragraph 2, the parts that I've yet highlighted in yellow. Essentially what this clause will do is divide refugees into 2 groups. Group 1 will have to comply with what's set out in paragraph 2 there. So if you've come to the UK directly from a country or territory where your life or freedom was threatened, and you have presented yourself without delay to the authorities here, you will be a group 1 refugee. If you do not fulfill that criteria, you will be what's known as a group 2 refugee. And you may wonder, well, what's the consequences of that? What's the difference? Well, the differences will be quite stark, because if you are in group 1 or group 2, the Home Office will be entitled to actually discriminate against you. So a group 2 refugee may have the length of any period of leave to remain or enter limited or less than a group 1 refugee. Their path to settlement, i.e. to have secure immigration status in the form of indefinite leave to remain in the UK, may be subject to different requirements if they're in group 2. So it might be harder to get permanent status in the UK. If you're a group 2 refugee, you may be subject to a no recourse to public funds condition, which means that for the time that you have permission to live in the UK, you cannot access public funds. And finally, if you're a group 2 refugee, the Secretary of State may be entitled to decide to not enable you to take up the right of family reunions. You may not be able to sponsor other family members to come to the UK. So that's quite serious and significant restrictions for group 2 refugees that will have a real life impact on the quality of life that these people will experience. And you'll see that the rest of the clause outlined here on this slide also gives the Home Office the power to treat family members of group 1 or group 2 refugees differently. So we're also looking at the wives, the partners, and the daughters of refugees who may have come to the UK via different countries or may not have made their claim at ports as they were expected to. So this is going to capture an enormous range of people. And I think it's really important to remember when we come on to look at the analysis of it, that this attaches to people who are actually refugees, people who will have been found by the state to be entitled to the declaration of refugee status. These are not people where there's any question about whether or not they are in fact entitled to protection. And I think that this is perhaps an important message to get across when it comes to parliamentary process and lobbying, because for all of the really toxic rhetoric there is around migration, I think the message that we're going to actually discriminate amongst refugees, depending on how they arrived in the UK and when they made their claim, may be the kind of message that the wider members of the public find untenable. And I think if we also look to the government's justification for Clause 11, this is found in the explanatory notes to the bill. It's very interesting because it goes back to the point that Stephanie made at the beginning about the rhetoric from the Secretary of State, and also that this is an act of vengeance or revenge for the hard-fought gains in the asylum system. So you'll see here that it says in the white paper that in the 12 months ending September 2019, around 62% of asylum applicants to the UK had entered the UK irregularly. And the second part that I've put in bold is that second paragraph. The purpose of differentiation is to discourage asylum seekers from travelling to the UK other than via safe and legal routes. It aims to influence the choices that migrants may make when leaving their countries of origin, encouraging individuals to seek asylum in the first safe place they reach after fleeing persecution. So we see there that what the government are concerned with is the number of people who are arriving in the UK via irregular routes. And interestingly, they think that migrants have a choice as to the journeys that they take. But when we come to look at a legal analysis of the real world effects of Clause 11, the government justification doesn't hold much water because it's based on mode of arrival versus the actual merits of the claim. So we are going to actively discriminate against people because of how they arrived versus whether or not, in fact, they are a genuine refugee. And obviously that goes back to the point that we made at the beginning about the number of people arriving in the UK. Typically, the top 5 nationalities represent genuine refugee producing states of origin. So again, query what is the actual justification for a two-tier system. It's also really important to stress, and this is a point that Unhcr have emphasised repeatedly, is that there is no legal justification in the Refugee Convention for penalising refugees, either based on their mode of arrival or in how we treat them when they stay here in terms of the conditions that apply to them. It also fails to acknowledge the push-pull factors for women and girls fleeing conflict. And there's this false notion of choice in the explanatory notes to the bill, that women and girls may have a choice when it comes to making perilous journeys in order to seek safety. And a particularly topical issue is the lack of current safe routes to the UK. And you can see that in the experiences of women fleeing Afghanistan and Ukraine. So just to put a real life example on the effect of Clause 11, an Afghan female judge, for example, doesn't have a lawful route to the UK. And indeed, most of evidence would suggest that a direct exit via Kabul to Heathrow, for example, is not possible because the Taliban control Kabul. So these women are often having to make very dangerous crossings into neighbouring countries such as Pakistan, from where they may be able to then make a journey to somewhere like the UK. Under Clause 11, that woman, the Home Office, would be entitled to refuse to give her particular lengths of stay in terms of her initial asylum grant. They'd be entitled to put her on a longer path to settlement. They'd be entitled to deny her access to public funds. And they would also be entitled to deny her the right to sponsor her family to come to the UK as well. And the same point equally applies to women and children fleeing the Ukraine. We've already seen that the humanitarian corridors are not functioning in Ukraine, and that many people are fleeing across Europe and being turned away at Calais. If Clause 11 passes, again, those Ukrainian women and girls would be the subject of actual discrimination, only because of the nature of the journey that they've had to make. And there's no real justification for that except to deter people from trying to claim asylum in the UK. And then finally, that clause fails to understand why it is that a woman may not be in a position to make a direct journey to the UK in order to claim asylum. There are very clear documented reasons why women may not be able to claim asylum without passing through a third country. The first question is it at all feasible for the woman in the first place to get directly from their country of origin to the UK? So that requires an analysis of whether or not they have the wherewithal to get to a British embassy to make an application in order to facilitate entry to the UK. very often women fleeing conflict or persecution don't have civic or political or legal freedoms to arrange their own exit in the first place. Even if they do manage to exit, they're often under the control of an agent, which could be a persecutor, particularly if it's in the context of family or gender-based violence, or a smuggler. And that's particularly the case for victims of trafficking and those who are fleeing domestic abuse. In addition, the countries that many people have to cross in order to claim asylum may not actually be safe for that person in question. And in particular, for women, they may face risks of refoulement, so being pushed back to an unsafe country, street homelessness, destitution, discrimination, and racism. They may have family or support networks in the UK, which they, for legitimate reasons, want to reunite with in order to make the transition from persecution to safety easier. And they may have historic links or cultural links with the UK as well, things like language, family ties, etc. In addition to that reason about failure to claim without directly with the need to go through third countries, the Home Office themselves recognise that many women delay claiming asylum, particularly around issues of gender-based violence, because of the nature of the impacts of gender-based harm on women. And their existing guidance recognises that they shouldn't be penalised for that, and it shouldn't automatically count against their credibility. We're taking a massive step back from that acknowledgement in this bill. So I've set up here just some of the text from the current and applicable gender issues in the asylum claim guidance, just to show the hypocrisy with the Home Office, because on one hand, it's already recognised that these are the kinds of barriers that women have to face. But on the other, this bill is going to make it a permissible form of discrimination in order to treat Group 2 refugees less favourably. So as I said, the real life consequences for women fleeing persecution are stark. A woman that makes a dangerous journey or who delays in claiming their asylum may in fact be classed as a Group 2 refugee and denied access to public funds, denied the right to reunite with family, and denied settled immigration status. And again, it's important to just bear in mind that this is not a person who's still going through the process. This is a person who's recognised as a refugee. And I think that's just worth highlighting because, again, it goes back to the lack of respect for the dignity and humanity of refugees by this government, unfortunately. So looking then at what those very harsh impacts are going to look like in terms of discrimination for women, if we look at public funds, for example, that means in practice difficulties accessing domestic violence shelters, denial of free school meals where it's linked to a parent's entitlements, potentially exclusion from the workplace because you're not able to afford childcare because you don't have any government subsidies. You're also putting children and women at increased risk of poverty, debt, substandard accommodation, and homelessness. In terms of the right to family reunion, this has real serious impacts in terms of the safety of women and girls. And UNHCR have pointed out that in Australia, when they restricted the rights of refugees to sponsor their family, they saw a threefold increase in the percentage of women and children who claimed asylum in their own right because they were forced to make dangerous journeys when previously they would have been the beneficiaries of a sponsored application. So that has real world consequences for women and children who have to flee situations of conflict. And then finally, implications for settled immigration status. Much of the psychological literature tells us that without some form of secure status, victims of trauma and torture are unlikely to fully recover from the trauma that they've been through. And by denying people the right to a safer, quicker route to settlement, we're impeding their recovery and their integration. And we're also affecting the children who are born of Group 2 refugees because those children will not be entitled to be naturalised on the 10-year route, unfortunately, as they would be now. And so just to flag before I hand over to Uba, in terms of further reading on particular effects of Clause 11, we've given you the link to the advice that we've produced for women, for refugee women, and also just to signpost that, of course, there are other areas of the bill that will affect women and girls, and that's something that we've been mindful of. And in fact, Garden Court will be doing a bigger event on the 29th of March on the bill itself, so keep your eyes posted for that. And so with that, I'm going to hand over to Uba now.
Yeah, before we do that, I was going to reflect on the fact that the case before Fauna, which was the first case in which it was established in the United Kingdom and set as a precedent for the world, was the case of Shah Islam. And that case was about women fleeing domestic violence. And the House of Lords concluded that in a system, the country that they fled from, Pakistan, where you could not seek access and protection from your state because of discriminatory laws, that the women in those circumstances were entitled to protection of the Refugee Convention. It was a landmark decision. We are at the moment, we've got a piece of legislation that went through Parliament, the Domestic Abuse Act 2021, which the government has made a priority to, at least in some context, to deal with domestic violence. But of course, it becomes a blind spot when it's women from abroad who are seeking protection from that form of pernicious harm. It is one of the scandals of that piece of legislation, although it has many positives to it, that women who have no immigration status are excluded from its protections. For example, in terms of access to housing, those women subject to domestic violence are still exposed to the hostile environment, denied any form of private accommodation, and cannot seek protection in shelter through access to local authority houses. And I think we need to make the links between the hypocrisy on the one hand of putting out an agenda that's supposed to be improving the position of those who face domestic abuse and those who survive domestic violence, but not extending that same protection to people because of their immigration status. Another case that came to mind when Emma was talking was the case of Adimi. Both Shah Islam and Adimi were in 1999. And Adimi said, it was a case concerning Article 31 of the Refugee Convention. And of course, whilst in practice, many people won't have a choice for the reasons that Emma have explained, the Refugee Convention itself, properly interpreted, does recognise the ability of individuals who are making these life-changing decisions to have to flee, forced out of their own countries, to make a choice on the basis of factors that Emma emphasised, in particular, obviously, family, but also language, cultural, safety reasons would drive people to decide to come to the United Kingdom. The Refugee Convention is a humanitarian piece of international law. It recognises that individuals making these sorts of choices, these sorts of decisions have choices. And it is something that we should also bear in mind, because what this legislation, if it comes into force, will do is actually be in breach of Article 31 of the Refugee Convention, because it will, for the reasons that Emma have said, penalise people for their illegal travel and entry to the United Kingdom. Of course, the government's solution is not to honour its international obligations in place since 1948 and 1951, but instead to suggest that those fleeing harm should apply to become fruit pickers. And if you needed anything else to understand the mentality of our Home Secretary and her understanding of our solemn international obligations, I think that really said it all. So with that, we are now going to look at other elements of the proposed legislation. Uber is going to address two aspects of it, Clause 31 and Clause 32. Clause 31 makes changes to the standard of proof and also to the definition of refugee, and in particular the phrase social group and what that covers. Uber, if you don't know her, and you'll see it when you hear her, she's a tenacious advocate. She specialises in representing those who face immigration, asylum, nationality problems. She specialises also in EU free movement, deportation and detention. And she regularly appears also in the tribunals, but also in the administrative court. And she's going to enlighten us about this aspect of the bill. Uber.
Thank you very much, Steph, and thank you, Emma, who is very kindly helping me to navigate these slides. So with that then, Emma, if you could go to the first slide, please. Thank you. So what I've set out here in this slide is a quick overview of part 2 of the bill, which deals with asylum. The clauses that I'm focusing on can be found right at the penultimate kind of line there, where it's dealt with in the interpretation of the Refugee Convention. And what you will see, if it's already not become apparent from the things that Emma has highlighted, is that there is a real attempt here to redraw and confine the meaning of the convention. And it really is an attempt to turn back the clock on well-established principles. And what that means is that it will have a consequential impact on who the convention applies to and how that person should be treated. So with that, if we could go to the next slide, I'm going to deal with clause 31, and it essentially has heightened the standard of proof. So you have there at paragraph 2 that it's all highlighted in red, the bits and put in a bigger font, the difference in approach. So in order essentially to prove your claim, what subparagraph 2 does is say that in order for you to be successful in your claim, you have to prove on the balance of probability, so the higher standard of the things that have previously happened to you. And at subparagraph 4, as you can see there, the lower standard, the reasonable likelihood approach, is applied when it comes to looking at whether you would be at future risk. So what does that actually mean? So if we could go to the next slide, please. So the main issues are that since Unhcr, it's been settled law that there is a single standard of proof in asylum claims, and that a person who was seeking asylum only needed to show that there was a real risk or a reasonable likelihood of persecution on return. And as I've just highlighted, what clause 31 does is seek to introduce a dual standard of proof. So essentially past facts on the higher balance of probabilities, and then future risk is on the lower real risk or reasonable likelihood standard. And what that does is, I said right at the beginning, it seeks to redraw and kind of really turn back the clock. That would essentially amount to a reversal of over 20 years of jurisprudence. And that was so clearly set out in Unhcr and Siva Kumar. And what is very clear is that this approach, this dual approach, is contradictory, that assessment of past facts and assessment of risk can't straightforwardly be separated from one another. And the reason why I say that is because the assessment of past facts, it means that protection will be denied to women who are reasonably likely to have been abused but can't prove it on the balance of probabilities. And in that context, the retention of the real risk standard, it just becomes meaningless. And past abuse is recognised just in and of itself to be the best indicator of future risk, but it will be discounted unless established on that higher standard. So it all seems pretty confusing, but that is essentially the confused approach that's being adopted. If we could go to the next slide. And so essentially, or sorry, just one slide back. So essentially what that does is that clause 32 introduces a mismatch between domestic asylum law as well as the requirements of the European Convention on Human Rights. So usually when you have a claim for asylum, you will have a claim under the ECHR as well, human rights, on the basis that, for example, that the persecution that you are facing under the Refugee Convention also on Article 3 terms also could amount to substantial grounds for believing that you would be exposed to a real risk of torture and inhuman and degrading treatment or punishment. And so that's very clear and was reaffirmed by the European Court of Human Rights in Babar Ahmed and the UK. And so what clause 31 actually means is that tribunals are having to apply two standards of proof to the same set of facts. So you've got this ridiculous mismatched approach, that you've got the dual approach, which is rendered meaningless, and then you've got the kind of standard approach when you're considering it under the ECHR. And so effectively, what that does is it undermines the coherence of asylum law, and the utility of even seeking the status of refugee will become impossibly high as compared to under the convention. And we say that's important because being recognised as a refugee provides you with internationally recognised status, and it should provide you with a path to security and settlement and integration in your host state. If we could go to the next slide. And so what this approach effectively does is it has a discriminatory impact on women and girls, and it will significantly worsen the asylum decision making that we already know is really crappy, I think is the official way to put it. And so even with the lower standard, it's being recognised by the courts. So it was recognised by Lord Justice Sedley, I think it was in Kanakaran, that that they face notorious difficulty, asylum seekers will face notorious difficulty in establishing the facts that they rely on. So if you combine that with the culture of disbelief that operates within Home Office decision making, it is going to be an absolute nightmare in order to try and prove your claim. The fact that many asylum seeking women and girls have also experienced traumatic events like rape, sexual assault and domestic violence, it's more difficult to prove than other forms of torture because it doesn't leave physical scarring, happens in the private sphere. And if you're from a country that does treat women in a discriminatory way, then it's less likely that there will be kind of research or evidence bases to prove that these sorts of things are happening. If we could go to the next slide, please. And so many women, as a result of their experiences, will have PTSD and depression. And it's well documented that PTSD and depression will have a significant impact on someone's autobiographical memory. And it's likely that the inconsistencies will be expected, even though they are genuine accounts of victims of trauma. So what the Secretary of State will do is latch onto the point, as I've seen numerous times, and I'm sure many practitioners have, that because someone is unable to give a time frame or is unable to give the exact details of the way in which they were abused or assaulted or persecuted, then that is used as a reason to show that they're inconsistent and therefore their account cannot be proved. However, we know that there is substantial evidence, and it's in more detail in the advice, which I'd recommend that you go back to, that's well referenced and highlights some of these really helpful background documents that show that PTSD and depression are associated with over general memory. So that in and of itself makes it really difficult to remember specific past events. So our memory in any event for dates and durations and sequences are quite poor. However, if you are traumatized, that's kind of doubled, maybe even worse. And that effectively was accepted or recognized in AM Afghanistan in the Court of Appeal. So if a person is presenting as internally inconsistent and their disclosure is piecemeal and fragmented because of how traumatized they are, again, as I've said, our experience has been that isn't kind of viewed in a way of looking at them as a traumatized person, but more as if that they are a liar whose claim cannot be believed. If we could go to the next slide, please. And so Mary Berry, I should say, has got absolutely nothing to do with this act or this bill. I really hope she doesn't. I think she'd be quite disturbed by it. But all of that essentially is to say that this is the perfect recipe for refusal. It will result in people being refused because of factors that they can't help. One of the points that Emma highlighted was that essentially there is this hypocrisy in approach. So you've got all this guidance on gender-based claims and the fact that, you know, violence against women can have an impact in the way that they are able to disclose. Well, you wouldn't recognise any of that guidance in the way that this bill has been drafted, and it really does turn back the clock. And so moving on then to clause 32. Thank you. You can see there what the bit that's highlighted in red. I'm very sorry, it's very small and it can be quite distressing seeing lots of small writing on a screen. However, these slides I think will be circulated, but the relevant parts for our purposes, the change is that in order to qualify as a member of a particular social group, you needed previously only to show that you met one of these criteria. So at 3, that you are a member because you share an innate characteristic, a common background, a characteristic or belief that's fundamental to your identity. Or the second condition was that the group that you were saying you were a part of has a distinct identity in the country because of how they're viewed. And essentially what clause 32 does, and the theme is taking a regressive step backwards, is that effectively the approach is that you need to satisfy both. So if we could go to the next slide, please. You can see there that, that gender isn't one of the convention reasons. However, it's previously been accepted or recognised in Fauna. So that's the case that Emma spoke about earlier, that the definition, when it's properly, the refugee definition, when it's properly interpreted, can encompass and does encompass gender-related claims. And so it wasn't seen as necessary in order for it to be recognised. However, next slide, please, Emma. What that means is that this approach that's been adopted, what actually constitutes as a PSG, essentially has been noted in regulation, in clause 32, that you need to meet both criteria. So I note there what's said in the directive. We can move on from that. Thank you. And so DH effectively says that, or rather clarified years of unsettled case law as to whether you needed to satisfy both limbs or just one of them. And DH effectively said that, and it was settled by the upper tribunal, that the limbs are alternative and not cumulative. And why is that important? Well, at paragraph 59 of that decision, it's very clear. The upper tribunal judge notes that there are difficulties that are created by the use of the word and. So that requirement for you to meet both limbs in order to qualify as a particular social group will result or can give rise to protection gaps. And that's effectively what paragraph 32 will do. I mean, it's there very clearly. By requiring a person to meet both limbs, you are not only reversing DH, but you are creating a protection gap where many women, many vulnerable people, including women and girls, will be left behind. And next slide, please, Emma. And so, as I've said here, this significantly impacts on women and girls in particular. If you are, as I've said, how many times can I say women and girls? That's the theme of International Women's Day. But it will give many victims of gender-based violence an additional hurdle to meet in order to obtain refugee status. If you're relying on membership, you've got to show, again, like I've said, not only that immutable characteristic, but also that you have a distinct identity. Well, why is that a problem? Well, if you're a trafficked woman, you're going to have to show not only that your status as a trafficked woman is an immutable characteristic, but also that you as a group are perceived as having a distinct identity. And we know that the second will be more difficult to establish than the former. I think what's really interesting is that this clause, in particular 32, was never mentioned kind of in that consultation. It suddenly popped up in the bill, and it's unclear as to why this regressive step which will disproportionately impact women and girls, was never brought forward for there to be a discussion of considering that women and girls are likely to experience specific forms of gender-based persecution. The last slide, please, Emma. And so this slide is effectively, it's Sisyphus, and he is trying to roll the rock up this hill that in Greek mythology Zeus has told him to push up. So effectively, this is how I see it. This was the overriding feeling that I had, that asylum seekers are like Sisyphus. They are being punished by the Secretary of State by virtue of just being asylum seekers, for having the audacity to have sought protection. And what this bill will do effectively, it will create this impossible situation where even if they make small gains, you get to the top, you will be defeated by gravity. It will come crashing down. And it's a really impossible task. And I'm sorry I haven't had much positivity to kind of add to this, but hopefully Priscilla will be able to do that. But I'll hand back over to Steph. Thank you.
Thank you, Uba. Well, I think you're right. The positivity comes not from looking at anything in this nasty piece of legislation, proposed legislation, but in the response that there has been to it from many women's organisations. And at the forefront of that has been Women for Refugee Women. We jumped at the opportunity to assist them with a piece of legal work on how and in what way this potential legislation would disproportionately impact on women and girls. And in the chat, you will have a link to the formal advice that we provided, myself, Emma, Uba, and a pupil in Chambers, Hannah. There's also an executive summary that highlights the main ways in which the legislation is discriminatory, two ways in which you've already had a detailed analysis from Emma and Uba, but there are other aspects of it, in particular the reintroduction of the fast track process, the use of accommodations centres, and of course the measures that are being taken in respect of victims of modern slavery and trafficking. So all of that, Priscilla in particular has led the response from Women for Refugee Women in coordinating the policy work that the organisation has been done, focusing on seeking to influence members of parliament to put forward amendments. And she's done an amazing job. Her work in Women for Refugee Women is, as I've said, it's their policy and advocacy coordinator. If you don't know the organisation at all, then you need to get to know it, because it's a fantastic organisation. Its primary aim is to give a voice to women who seek asylum, to tell their stories, to and on that basis to influence decision makers. It advocates for a humane asylum system, and Priscilla's role is to focus on government policy. Before that, Priscilla had experience of working in African countries, in Egypt, as the senior legal officer, also for an organisation supporting claimants seeking asylum across the Middle East and Africa. And she brings all of that first-hand experience and humanity, which is the hallmark of this organisation, to her policy and advocacy work. And we're very pleased that she's part of our International Women's Day celebration today. Priscilla.
Thank you so much, Stephanie. That was all too kind. Just thanks as well for having me here today. It's an absolute pleasure to be on the panel with such brilliant women. So thank you for the opportunity. By way of introduction, just a bit of background, I suppose. Women make up around a quarter of all asylum claimants in the UK. So I just wanted to sort of highlight that, because it's not a small number, contrary to what the Home Office has sometimes suggested throughout the bill's passage. Now, the department doesn't collect any sort of detailed statistics or publish any statistics on the types of persecution that women face, and whether sexual violence or other forms of gender-related persecution make up any part of their asylum claim. But what we've found through our research at Women for Refugee Women over the years is actually that a high proportion of women seeking asylum have experienced some form of gender-based persecution in their countries of origin. So, for example, in our 2020 research, we spoke to about 106 women about their experiences of destitution. And we found that 78% of those women had experienced some form of gender-based violence. So we're talking rape, FGM, domestic violence, so-called honour-based abuse, forced prostitution, and so on, just to name a few examples. Now, simply put, the Borders Bill will harm these women. But before I sort of go into specifics about the advocacy that we've been doing, I just want to share with you a story from a woman in our network to really illustrate the challenges that women like her already face in the system, as Emma and Uba have already highlighted. Now, this is Gloria's story. Gloria was born in the DRC. In 2011, she was living in Kinshasa with her husband, and both she and her husband were supporters of the opposition political party. And it was at that point that the government started to suspect that her husband was talking to journalists about human rights abuses and began targeting both him and Gloria. Now, Gloria was raped by soldiers and she was taken to prison. When she was released, she and her husband fled to Congo Brazzaville, but unfortunately they were forced back into the DRC in 2014 and targeted by government soldiers once again. This time, Gloria was raped by several soldiers and held in a detention centre. While she was there, a strange man approached her when she was being taken outside the camp to use the bathroom, and a guard handed her over to him. The stranger told Gloria that he would help her and eventually took her to the UK under a false passport. In the UK, she was locked in his house and she was forced to have sex with him and his friends for weeks until a cleaner helped her to escape. This woman then encouraged her to claim asylum, but Gloria was too scared to talk about her traffickers in the interview. We know the experiences that, the challenges that traumatized women face in disclosing the harrowing acts of abuse that they suffer. She was too scared to talk about the traffickers in her interview, so she couldn't explain why she hadn't claimed asylum earlier. Her male interpreter at the interview didn't speak Lingala fluently and actually got angry at several points during that interview when Gloria tried to clarify some important parts of her story. Gloria had no medical or mental health support at this point, like many asylum-seeking people, so she was unable to disclose the very extreme sexual violence that she was faced with. And unfortunately, her lawyer never explained to her that the experience of being trafficked was relevant to her asylum claim. Gloria was refused asylum and she was taken to Yarlswood at some point where she was detained. And of course, given her previous experiences of incarceration, she found this incredibly traumatic. Now, after she was released, she did come to Women for Refugee Women to seek some help. She was forced into homelessness. She joined one of our creative projects, and gradually, over some time, she began speaking about the persecution that she faced in her country and also about her experience of trafficking. We then ensured that she was referred to the National Referral Mechanism, and she now has a positive reasonable grounds decision and is putting together further submissions for a fresh asylum claim. We really hope that we can support Gloria and other women like her to rebuild their lives once she gets leave to remain. But the protracted process, the long wait, the periods, the years that she has spent being destitute in the UK has had an absolutely devastating impact on her physical and her mental health. She suffers from severe PTSD, depression, and has suicidal thoughts to this day. Now, the bill's going to make it even harder for survivors like Gloria to access refugee protection. And, there's so many aspects of this bill that are problematic. It was really challenging for us as an organisation who actually have never done this type of work before, but also an organisation that is relatively small to sort of decide, which one of these massive list of horrendous clauses should we focus on. And of course, we looked at the experiences of the women in our network, but we also, just thought really carefully about where we could most add value, given the broader advocacy that was taking place across the asylum sector. And the focus for us really has been Clause 11, that two-tier system, and Clause 31, well-founded fear, and Clause 32 on particular social group. And as we've entered those later stages of the bill, we've sort of focused on the latter two clauses that deal with decision making. And that's essentially because over the years, we've heard countless women share with us how their experiences of gender-based persecution were not believed by the Home Office, how they were improperly supported to go through the asylum system and feel that they were unfairly refused protection in the country. Now, when women are refused asylum, as I'm sure many of you here know, they're generally made destitute. So government support, financial support, housing support is withdrawn at that stage. And of course, there's no right to work. Now, our research has documented quite extensively the harmful effects that has on women's physical safety and mental well-being. And particularly in terms of the increased risk that this puts women to further violence and abuse in the UK. I won't go into detail about that research. It's called Will I Ever Be Safe? And you can find it on our website. But I just want to share one rather harrowing statistic with you. So we found that a third of the women that we spoke to for that research who had been raped or sexually abused in their country of origin were raped and sexually abused again in the UK after they were made destitute. Now, that's just a really astounding statistics that I find really hard to digest, almost 2 years after doing this research. And it's really experiences like this that encouraged us to focus on clauses 31 and 32 on decision making, as I say. Now, over the last couple of years, the UK government has tried to reassure women and girls that, it's taking violence against women and girls seriously. There was a Vogue strategy that was published in July 2021 that explicitly commits to bringing real and long-lasting change, as it says, to the issue of violence against women. It recognises that this issue is far too prevalent and that there are too many instances of survivors being let down. And we've seen these statements continue ever since that strategy was released. And when the new plan for immigration was presented in Parliament, the Home Office, the Home Secretary did once again speak in support of women. And specifically, she asked, where are the vulnerable women and children that the asylum system should exist to protect? Now, since the new plan was released, the Home Office has repeatedly suggested through statements, when they refer to women being elbowed from the system to, pictures that are posted on its Twitter page, that the bill will protect women. This is a bill that will help women, whilst at the same time actively pushing through measures that we know that other experts have clearly stated will seriously and disproportionately harm them, and at the same time whilst having the audacity to claim that addressing violence against women and girls is a government priority. Obviously, engaging with the parliamentary process was a no-brainer. We wanted to do that to try and secure some changes to the bill, which we knew would be very difficult, but we have to try everything that we can. But also to lay the foundations of future advocacy, because as I say, we know that it's not going to stop here. But as a team, we were really clear at the outset that we needed to bring the wider violence against women and girls sector along with us in this, on the bill and the advocacy that we're doing. We've got a government, as I say, that's constantly telling us that, we're committed to tackling Vogue. And it was just really important to us that, we spoke as a women's sector, that we highlighted the disparity in, government strategy, government policy and government statements, with the hope that that would create the pressure for change in the bill. And, of course, we can't call ourselves a women's sector if we're not speaking for all women. So I'm really hoping that the work that we have done over the last year will be helpful, not only in terms of pushing for change, in the bill when it becomes law, to pushing against those provisions, but also in work that we do to advocate against other harmful policies. To share some quick examples of the work that we've done with the Violence Against Women and Girls sector, we've worked with the Brilliant and Violence Against Women and Girls Coalition, who have been a tremendous support. We put together a template to encourage other organisations in the sector to submit evidence to the Public Bill Committee. And a load of them did, and you can find that, of course, on the official website of the bill. Women for Refugee Women also co-organised the Refugees Welcome Rally, which I believe was in October, that my colleague has just posted the photo blog from there. And lots of the organisations, again, from the Violence Against Women and Girls sector turned up to that. We've also worked with the sector on an open letter to Priti Patel, calling out the bill and its harms to women, and this hypocrisy, of sort of saying that you're committed to VAWG whilst pushing through these measures. And really pleased that 52 organisations signed that letter, including some organisations that work very closely with the Home Office. So we were really, really pleased with the breadth of support there. And many of those organisations then went on to co-badge the briefing that we did with the wonderful ILPA on Clause 32. As I say, these are just a few examples, and really happy to kind of talk more about this if people want to hear about that later in the Q&A. So in short, despite our very best efforts, no meaningful attempt has been made by the government to address or listen to the serious concerns that women with lived experience have been raising, that our organisations have been raising, and I would go as far as saying that they have been brazenly ignored. And quite frankly, this is just really shocking, because we've got so much research that's been done over the years that documents, the significant failures of the Home Office in delivering a fair asylum system. We've also got a ton of research on the reasons for why women who've survived gender-based abuse may be wrongly denied protection in this country. That research, has shown, for instance, how decision makers often fail to understand the nature of GBV, not just in terms of the impact that has on disclosure, but also how it fits into falls into the Refugee Convention, and therefore falls within, the UK's protection obligations. But instead of, fixing these issues, instead of making changes that would support survivors to access safety, the changes to the well-founded fear test and PSG are just going to make things a lot worse. Now, I think Ubal was alluding to this in her speech. From our understanding, these changes to clauses 31 and 32 have come from nowhere. There was no indication, as far as we know, prior to the new plan or the bill, that the government was trying to change the well-founded fear test or the PSG definition. So a big part of our efforts, in this, with our advocacy, has been to try and get the government to justify these changes, to explain what their intentions are, to get some statements on the record that we can then use as we continue to challenge these clauses when they become law. So with that in mind, we've worked really closely with ILPA, as I say, and we've got some amendments tabled in the Lords, which you will find in our briefings that we can hopefully share in the chat. And we supported peers in putting questions to the government minister to get statements to this effect, to find out as well, what the government's plans are in terms of monitoring the impact of these clauses on vulnerable groups. As has been explained, that equality impact assessment that we have is extremely poor. Superficial and inadequate is how these three barristers have described it in their legal opinion. Just a bit more detail about clause 31 then. So I won't obviously explain that. Uba has done that brilliantly. I just want to share again a story to emphasize the real life impact of the struggles that women already face in terms of being believed. And this is Dina's story. So Dina is a lesbian woman from Nigeria, where sexual acts between same-sex adults are illegal. Now, when her family found out about her sexuality, they beat her and attempted FGM. She came to the UK on a student visa in 2012, but when her visa ran out, she felt unable to go back as there was a real risk that she would be persecuted there. So she remained, and unfortunately she was picked up by the Home Office and detained for 6 months at Yarl's Wood. Now, while she was there, another woman told her about the asylum process, and it was at that point that she made her application. She told the Home Office about her sexuality and even showed them the scars from the attempted FGM and other acts of torture that were inflicted on her by her parents. However, the Home Office refused her claim. Her solicitor challenged the decision, and the judge ordered the Home Office to look at it again. But again, the Home Office refused it. They said they didn't believe that she would be a risk of persecution if she was returned, and they didn't believe her sexual identity, which is something we hear so often from LGBTQI plus people who are seeking asylum. And this was despite all the evidence that she shared, and a very compelling, consistent, and coherent testimony. Now, she's still appealing this decision to this day. 5 years on, her life has been on hold. And as I say, if Clause 31 becomes law, it will be even more difficult for women like her to access protection here. Turning to the justification for this, the government has basically argued that, by changing the test to Clause 31 with this two-tier test and the introduction of the balance of probability standards, they're bringing greater consistency and clarity to decision making. And it's really hard for me to keep a straight face when I say that. It makes absolutely no sense at all. As many legal practitioners will tell you, including the women in this room, the current test is adequately clear. And of course, if there's not, there are other things that are at the Home Secretary's disposal. She's free to amend policy guidance. She's free to expand training, right, for caseworkers. What they don't need to do is fundamentally change the test. And in fact, as Uba has already mentioned, and as other legal practitioners have noted, that kind of separation of objective and subjective fear actually increases the potential of confusion and therefore of a greater number of inconsistent and incorrect decisions. The government's also claimed that the new test is needed so that only genuine refugees are able to obtain protection. That term, genuine refugees, makes me queasy every time I hear it. And this is probably what I would say the poorest of all excuses in light of the culture of disbelief in Home Office decision making that we know plenty about and that I don't need to explain further. And just to give you some stats to highlight how ridiculous this particular justification is. According to the latest statistics, 48% of appeals against the Home Office's decisions to against the Home Office's decisions to the first year tribunal are successful. And in fact, if we look at the appeal success rate over the 10 years, you will see that that's been steadily increasing, up from 29% in 2010. So what that shows you, of course, is that the Home Office is making an increasing number of incorrect decisions in its initial asylum decision making, yet is claiming that somehow there are all these people who shouldn't be entitled to refugee protection, getting it in the UK. So total myth. Now, moving on finally to Clause 32. Again, another case study to just really highlight the impact that this change will have. I want to share with you Rosa's story, who's actually a former client of barristers at Garden Court. Rosa came to the UK escaping domestic abuse. Her husband was a powerful man in her country, and over the course of their relationship, he was extremely violent towards her. Now, when she arrived here, she didn't know anything about the asylum process. She didn't have legal advice at all. She overstayed her visa, and again, she was locked up in detention at that point. And it was then that she found out that she could claim asylum. But her claim was initially refused. And this was despite a medical report that was provided that confirmed the physical injuries, the psychological injuries, that really showed that her account was, again, coherent and credible for all intents and purposes. Her case eventually went to hearing. Now, at the time of her hearing, she only needed to establish But either she had an innate characteristic that couldn't be changed, in this case that she was a female victim of domestic violence, or that female victims of domestic violence in her country of origin are perceived as being different by the society there. She was correctly identified as a refugee by the tribunal, we're really, really pleased to say. But if if the bill goes through and if the test is made cumulative as opposed to either or, it would be very difficult for her to prove to obtain protection today. And then actually the barristers at Garden Court have said that most likely she would be unable to get refugee protection because she would really struggle to show that she's part of this group that's perceived as distinct in her country of origin. Now, in terms of the justification for clause 32, again, the government's argued that there's a need to bring clarity, that there's no settled definition of PSG. And as with clause 31, they've cherry-picked authority, bits of case law and legislation to poorly justify their position. And as Ubah has said, they've relied heavily on an EU directive from 2004. And what they've basically said is that, how can you possibly have a problem with this test in the directive? It's in EU jurisprudence. Like, are you saying it's unfair? Are you saying it's wrong? But actually, that's exactly what our specialist tribunal, the upper tribunal, has said, and we've pointed that out in our briefings with ILPA. And there's absolutely no reason for why that the judgment of our independent judiciary should not be accepted. And, and that directive as well, like, yes, it's a test from the directive, but it's a directive that, explicitly states in its title, seeks to lay minimum standards for refugee protection. It, goes as far as explicitly permitting member states, encourages member states to adopt more favourable provisions. So our question really is that, why is the government trying to, why are they hell-bent on adopting a definition that would harm women? You don't need to stick to that EU definition. Our tribunal has highlighted the protection gaps that would arise from this. And if you are committed to tackling violence against women, you should actually be focusing on what the Unhcr are espousing, rather than, looking at the EU, looking at the practice of other member states. So in short, if this wasn't clear already, this change, as with the change to clause 31 and well-founded fear, is nothing to do with clarity. And as Baroness Lister, highlighted so eloquently during committee stage, if it is about clarity, there's no reason for why that either or test that has been confirmed by our upper tribunal could not be put into the primary legislation. There's no reason for us to go to the cumulative test that will only make things harder. I'm not sure if this was already mentioned, but I think it's quite significant to mention this. It was actually Ubah who brought this to my attention. The Home Office didn't appeal the upper tribunal's decision in 2020, the one that brought clarity to the PSG test. And we actually heard nothing more on the matter until we saw the Nationality and Borders Bill. And of course, there's a really, really strong argument here that it seriously undermines the rule of law if, when a Home Secretary disagrees with a decision of a court, she legislates rather than appealing that decision through the normal channels. Ubah's already mentioned the fact that, there was no mention of the PSG change in the new plan for immigration. Just to highlight, what that means in practical terms is that there was no opportunity for public or expert feedback on this. And with the equality impact assessment as well, the clauses were not explained in that. That assessment, does sort of acknowledge that there are sort of a bunch of vulnerable groups, including women, who will be disadvantaged, in several ways, but doesn't adequately engage with those concerns, doesn't give us anything reassuring in terms of how those impacts will be monitored. And we also know that the Home Office doesn't collect statistics on GBV survivors. So on a very, very basic level, how is it that they can conclude, as they have in the equality impact assessment, that these and other clauses, the impact of them will be justified and proportionate on women when you don't even have the right data to do that assessment. And so, during the parliamentary process, one thing that we have tried to do is support peers in asking the government minister, about statistics and their plans to, what statistics do you plan to collect and share if you are indeed serious about monitoring the impact on vulnerable people. Finally, just to kind of round off, the government has said, with this bill, it's one of their key policy objectives. You will see it in the new plan that they want to better protect and support those in genuine need of asylum. And it's hard just, not to laugh when you read this, when you look at the absolutely, just cruel measures that are in this bill. And, all we can really emphasize is that if they're serious about this, if they're serious about protecting women, they first and foremost need to focus on Unhcr standards. They need to listen to women with lived experience of going through the system. And they need to listen to, the expert advice of practitioners, of specialist organisations such as Women for Refugee Women. I'm aware that I've talked for a lot, so I'm going to leave it there, but thank you for listening. And do get in touch if you have any questions at all. My colleague will put my email address in the Zoom chat for you.
Priscilla, thank you very much. We've got some questions in the chat, which we'll do that first so that people's time doesn't get squashed for that before I draw the meeting to a conclusion. But it may be just to follow on, Priscilla, if one question that was asked was, what's the assessment of the possibility of amendments being passed in the House of Lords?
Yeah, excellent question. So with these amendments, we got them tabled at report stage, and actually the work that we were doing, a lot of work with the sector and other people to basically push them to a vote. Because of course, having an amendment tabled isn't the same thing as it being voted on. Now, unfortunately, despite our very best efforts, we weren't able to get this to a vote. And it's really, really important for me to emphasize that, the Labour front bench were entirely in agreement with our concerns, entirely in agreement with our amendments. But the reality is that there is so much wrong with this bill. They had to pick and choose what it was that they were going to push for, and clauses 31 and 32 did not make the cut. So yeah, that's sort of, that's really where we are at. But we, as I say, we still were keen to get the amendments tabled because we thought it was an important opportunity to, again, get further statements on record from the minister that we could then use later down the line. And one of the things that I'm particularly keen to get is, as I say, there aren't those statistics on GBV survivors. If we can get a concession from the government, a sort of commitment that says, okay, we will collect statistics on GBV survivors, we will collect statistics on what grounds women use when they're claiming asylum, then that could be, something that could really help us later down the line.
So I think that that kind of sets up the themes of the other questions that we have had, which is how can we challenge these pieces of legislation when they come into force? And we had a question from, I think it was Kama at the Refugee Council, who asked, how can you challenge the compatibility or incompatibility of the clauses with the Refugee Convention itself? So I don't know if Emma, you would like to have a go at that question first in response to that. It's quite a tricky one.
Thanks for putting me on the spot. The difficulty, Kama, obviously, is that in order to bring those kinds of cases, we have to first wait for the bill to pass into law. So and that is possibly, as Priscilla has said, likely to be a reality, unfortunately, just given the composition of Parliament. And so when the Act is in force, which is probably from Easter of this year onwards, we're looking at, it's going to be really important, I think, for practitioners across the migration and asylum sectors to be really vigilant to the individual cases that are coming through, and to start paying attention to the decisions that are being made by the Home Office, because we're going to have to challenge individual cases on their merits in the courts. And that won't be a quick process, unfortunately. That will be, it will be slow, and it will require, first of all, potentially exhausting appeals in the tribunal or claims for judicial review in the upper tribunal and the High Court. And then eventually the senior courts are going to have to look at these big international public law questions about to what extent is the UK government entitled to act contrary to their international obligations. There are obviously legal mechanisms that are available to us in terms of the kinds of arguments that we can run in the higher courts. The way the Refugee Convention typically applies is through the immigration rules and through published policy in the UK. And so we'll have to be looking at creative ways of challenging this primary legislation, and indeed the secondary legislation that's going to be made under the Act, using general principles of UK public law and also the human rights jurisprudence that we have as a result of the ECHR. And I think there are, obviously, what we've tried to highlight today are very clear outliers in terms of international standards. But the reality is too that we have to be mindful that these are big pseudo-political questions too, that often the judiciary may be influenced by the extent to which things have been debated in Parliament and consulted on. But I definitely think we have to be vigilant as a sector, pay attention to individual cases, have discussion and monitoring of individual decisions, and try to spot the trends. And as a sector, we need to hold the Home Office to account through strategic litigation in individual cases. And I think it's only through collaboration that we're going to have any possibility of challenging the worst parts of this bill, unfortunately. I think that's what I would try and say at this stage anyway.
I don't know if, Uber, do you want to add anything to that? I think you're muted.
Oh God, sorry. You thought I'd have learned two years later. No, Emma's been very comprehensive, I think, about that. But I think actually the one thing, having said that, the one additional thing I would say is, and I think it's what Priscilla mentioned, it is really, really important now that if you are in these organizations, NGOs who are working with women, to start gathering evidence now so that we can kind of start collating, so that we can show the real impact that it would have had it not been for these clauses, or rather, you know, these provisions being in place, this person would be successful. So as Emma says, I think collaboration is key.
I think the specific question that was asked about compatibility with the Refugee Convention itself is very, very difficult, because the Refugee Convention has a very peculiar status in our system post-EU, post-Brexit, and it is really only through the rules. So it isn't going to be obviously like the Human Rights Act, where there is a provision that will mean if it's incompatible, the court can make a declaration. It will be about interpretation and attempting to see what arguments you can run, but it's going to be quite difficult. The real issue is going to come with the compatibility with Article 3 of the Article 3 of the ECHR, and incompatibility. So there is clearly going to be conflict between the approach on a standard of proof in Article 3 and the Refugee Convention. So I think that the conflict that will be created will be on the basis of the Human Rights Act, and of course there's a political dimension to that. The government wants to have its fights about the ECHR, and it putting blocks on their ability to address these issues. So it's no coincidence. They know full well that many parts of this legislation will not be compatible with the ECHR. And I think they're ready for that, and they'll see what consequences arise. But there are arguments that have already been foreshadowed insofar as there was a wholly inadequate equality impact assessment. It is discriminatory in its impact. And so Article 3 and 14 of the ECHR may provide us with a bedrock for an argument about the disproportionate discriminatory impacts, but again, the message that's coming out is you need very good evidence about that and how that's going to be is going to disproportionately impact women. And of course, it's always been a strategy, a long-term strategy. You have to be in at this stage to challenge what they're doing, to build the information networks and the evidence that will show that this legislation does have the discriminatory effects that we've identified in principle in our advice. And so that's what's going to be key if we're going to get any strategic general challenge off the ground. And of course, the case law recently from the Supreme Court on when you can bring generic challenges has got very much more difficult as well. So that doesn't mean to say it shouldn't be done. Of course it should. And it will be the Human Rights Act and equality legislation that gives us our legal foundation for strategic challenge. But as with everything, it is about the context. And we do have an opportunity at the moment because so much of what this legislation is based on has no bearing in reality, not the reality of the experience of those currently struggling to push the stone up the hill and to get protection in the UK. But of course, as we know now, we're in a real life situation. People do not sit in their homes waiting to be bombed or occupied by an oppressive force. They leave. 1.5 million people have left the Ukraine in the last week. Then all of those people are doing what the government says this legislation is supposed to stop. People seeking protection, seeking practical solutions to real life situations. And so although it's pretty bleak in terms of the government's majority, there is an opportunity here. So I hope that the work that people do, both in their casework and also in their wider campaigning with organisations like Women for Refugee Women, will keep on the agenda this pressing issue and the impact on women of these measures. So those were the questions on strategic litigation, and I think that was all of the two questions that we had. Yeah, so all is not lost, and as we say, even if you cannot bring strategic litigation or successful strategic litigation, individuals still need to have their cases fought as hard as possible, and there'll always be ways of seeking to support individuals through individual case law. So I think on that note, I'd probably sum up the seminar today. I think we see that there's a complete disjunct between this proposed legislation and reality. There is a real risk, a real possibility, in fact, probably a certainty, that this legislation will result in many people who are genuine refugees being denied protection and being expelled from the United Kingdom. And it will mean that the system, which is already a system based on abuse of asylum seekers, will intensify. There's been many reports that have been done over the years about the culture of disbelief. Organisations like Medical Justice describing the detention system as a second torture for victims of torture. Similarly, the Freedom from Torture talking about the severe adverse impacts on mental health of a system that rests on denial, disputing the person's account, and women in particular, for all the reasons that have been explained by Uber and Emma and Priscilla, are particularly exposed to having their accounts being rejected as untruthful. When you come to a country expecting respect, safety, and security, that's one thing. People do have that expectation. They still believe that the United Kingdom is a place in which human rights are respected, and that's an expectation that's dashed. But worse than that, they do expect to be believed when they come and give their accounts, harrowing as it is, of gross abuse, torture, ill treatment, often sexual violence and rape. There has been no Me Too for women seeking asylum and protection in the United Kingdom. There is no recognition that their accounts need to be believed because they give those accounts. We hear a lot about the reasons why we have such a failure to prosecute rape and sexual violence in the United Kingdom. We know the answer is because the women who make the complaints are not believed, and there's not an assumption that their accounts are truthful. And we know through many years of working in this field that it is perhaps the harshest aspect of our system, that people's lived experience is denied. Worse than that, they're accused of being liars and inventing accounts. There is nothing more damaging to the human spirit and to the moral and physical integrity of a person to have your account of torture and abuse rejected. And I think Priscilla was right to point out the hypocrisy of, on the one hand, recognizing, or at least in principle, recognizing that that's the experience for women facing domestic and other violence in the United Kingdom, but not when it comes to people from abroad seeking protection. And I think that's a big takeaway that we need to have. That's a big debate and context in which we need to engage. So that is the negative, and that is the huge challenge that we face. But I would just say that we can take inspiration as women working in this field, that there is always a response, and there is always cooperation and coordination and collaboration to challenge these measures. And again, I started off by referring to the domestic workers who stood outside Parliament. Their campaign to get the vote on the right to work has been hard fought for over a decade by many organisations, and that's where we need to keep our inspiration. Wherever there's a detention centre that houses, that accommodates asylum seekers, whether it's at Yarlswood or Harmondsworth or Campsfield, wherever it was, there's always a campaign group to shut it down. And they may not always succeed, but there's always voices there who want to lend their support and solidarity for people seeking asylum. And we are doing that with this meeting tonight. And I hope that it will carry on, because we do all stand in solidarity with women and girls who's seeking protection and sanctuary in the United Kingdom. So on that note, I'd like to say, if it's appropriate, happy International Women's Day. And I hope that you found the seminar interesting and also inspiring. And thank you for participating. I should just say that in terms of the bill as a whole, Garden Court does have a one-day seminar that's looking at other measures, the full ambit of the measures, on the 29th of March. And if you did want to attend that, you need to sign up on our website, because there are limited physical places. It's going to be in person, although it may be hybrid. But if you wanted to attend in person, you need to join up to sign up for that. And I think that might go into the chat. And hope to see some of you actually physically in person. It would be nice to get back to that. And thank you for participating today.